All right, you may be seated. Good morning, jurors. Thank you so much for your patience. All right, next witness.
Your Honor, we call P.J. Pesh.
Just said before the judge, raise your hand.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, have a seat, talk into the microphone. Thank you.
Right, sir. And you please tell the jury your full name.
It's Paul Peter Pesh Jr., but I've always been referred
Pesh, what do you do for a living?
I direct and write movies and
How
television.
long have you been in the business of directing and writing movies and television?
35 years.
Can you give the jury a background on your movies that you've directed and kind of a biographical sketch?
Sure. I attended Columbia University and studied under Martin Scorsese and did a short film that traveled around the world. I wound up getting a deal at Paramount in 1990. Directed a film for Roger Corman in 1991 that I wrote and directed. In 1995, I directed a Western with Sam Elliott that we actually shot at Bonanza Creek Ranch. That was a also rather lower budgeted short schedule. I've directed 6 feature films and close to 100 hours of television. I've created television shows, written and sold movie script, Paramount, Warner Brothers, HBO, Universal, Fox. Anything else?
That's a really good background, and I just want to ask you with regard to the Western on Bonanza Creek. That's also the site of where Rust was found, is that right?
That's what I understand.
Yeah. Well, Mr. Pesh, it sounds like you have experience also with movies involving firearms.
Yes. Many of the television shows and 4 or 5 of the 6 films, 2 of them were Westerns. One of them was one of the Sniper series with Tom Berenger. One of them was Smokin' Aces, which had a considerable amount of gunfire.
In your work on the movies involving gunfire, have you had the occasion to work with armorers and prop masters?
I have.
And actually, in all of the movies you've done, I'm certain you've worked with prop masters.
Yes.
Okay, sir. And with regard to those movies that you've directed in television, have you worked with directors, first assistant directors, and understood people's roles on these sets? With regard to armorers, have you ever worked on a prior film in which an armorer had split duties as an armorer and a props? With regard to this situation where there is a gun-heavy set I will represent to you, would you think, in your experience and what you've seen, it would be advisable to have a part-time armorer doing 2 jobs?
I would say that would be highly
Whose responsibility is it to properly staff with regard to the movie functions?
the line producer or the unit production.
When you have a set involving upwards of 20 firearms, would it be, in your experience, possible for a part-time armorer to manage that?
I wouldn't imagine so. One person can, each one of those weapons needs to be tracked pretty consistently for the set to remain safe, so I don't see how a single person can keep their eye on 20.
With regard to overall set safety and your experience and background, who is in charge of that?
The first AD is considered in all of the published safety advisories the chief safety officer on the set.
Are you a member of various guilds?
I'm a member of the Writers Guild, the Directors Guild, SAG-AFTRA, which is the Actors Guild, and I also happen to be a member of the Musicians Guild.
Okay, so when you talk about safety rules, are some of those from those guilds?
Yes, I can't remember the name of the organization, but they sort of collectively represent all of the various guilds and issue recommendations for safety that they recommend attaching to the call.
Is it, in your experience, also something you've seen where there will be daily safety meetings on set, especially in a gun-heavy set?
Expert?
Yes, Your Honor. I believe he can give lay opinions on his experience, but also we would tender him as an expert. So, Mr. Petch, you were discussing some of those safety rules. Now, would it be, in your experience, advisable for production to convene daily safety meetings?
Yes, in fact, it's recommended by all of the published literature by the guilds. And it's been they recommend that a safety meeting takes place anytime there's to be any stunts, firearms, special effects. But it's been my experience that in the last 7 or 8 years since the tragic incident with the camera assistant who was killed on the railroad bridge, that every first AD I've worked with, regardless of what's happening that day, on the call sheet has a quick safety meeting, just running over and reiterating basic safe practices.
And you as a director, is that something that you advise and you practice?
I don't give safety meetings. That's the job of the safety officer, the first AD, but I think it's a great idea.
In your experience in interacting with first assistant directors, if, for example, there's a situation where a set is rushing, there's safety issues occurring, does the first assistant director have any responsibility in that respect?
Most definitely.
And what would that be in your experience? What would you expect to see happen?
My experience has been that the first announcement to everybody, slow down, this is not safe, or we're not doing this, or just takes charge. And if there's a specific issue with a crew member, they'll pull them aside and discuss the issue and consult with stunts or props or firearm with it.
Is that also true, for example, if you have a issue with an actor? For example, firing a blank after somebody yells cut. What would the first AD be expected to do in your experience?
Speak with them and indicate, look, when cut is called, usually the only person that can call cut is the director, but if it's a safety issue, anybody can call cut. And once cut is called, everything needs to stop, because if there is a safety issue, obviously, that somebody's noticed, nothing else should take place. So yes, the first AD should speak to that performer.
When it comes to safety, what is your view as to everybody's responsibility on set?
Well, again, it's not just my view, but again, in the published literature of the various guilds, they indicate safety is everyone's responsibility. If there's a safety issue, there are anonymous hotlines for anybody to call and raise these issues.
And are those anonymous hotlines, are those published generally in your experience working on set?
They are usually with that safety recommendations that are attached to the.
Those hotlines, what do they provide for people to be able to do if they notice a safety failure?
You can call someone from your guild. Each of the studios has their own separate hotline. As far as I know, that will allow you to anonymously, so you don't, look, if you report something, you could put your career in jeopardy. Nobody wants to do that, but the idea is that a representative can provide that information to somebody who will take action, such as the producer, the UPM.
In your experience, have you worked and seen the interaction between prop masters and armorers?
I have.
And can you tell the jury, in your experience generally, how they interact? Who's in charge of the firearms and who's in charge of the ammunition, and then what the prop master role is?
Well, the prop master, more often than not, hires the armorer because that's a subset of that department. But the armorer is in charge of all ammunition, all firearms, maintaining them, keeping them safe, and inventorying the ammunition.
With those duties and responsibilities, would you believe it to be important in your experience to accord the armorer adequate time to do those duties?
Yes.
And would it be important to accord adequate resources for that armorer to do those duties? If there is a scenario where the armorer is dealing with a gun-heavy set, not having those resources, who would you expect to assist that armorer in getting those? There is a situation where there is a scene, a video, something's happening, and both the armorer and first assistant director witness a safety violation involving a weapon, for example. What would be your assessment whether one or both of them should say something about that?
I would say both of them should say something about it and figure out why it happened and make sure it doesn't.
Your Honor, I have no further questions.
Cross-exam.
Mr. Pesch, I just have a couple follow-up questions for you. Thank you for your time today.
Certainly.
So anyone on the crew can stop filming due to safety concerns, is that right?
That's right.
And that includes Ms. Gutierrez.
That's correct.
And sir, did you read or watch the statements of Ms. Gutierrez in preparation for your testimony?
I did not.
That was my understanding. So are you aware that on October 21st, 2021, Ms. Gutierrez was not inside the church with the gun, not because she was working on props, but because she was just doing some other armorer duties? I need to restate the question. Do you remember?
Yes,
okay.
please.
So my question for you is, we saw some interviews from Ms. Gutierrez, and she does explain that she was not in the church because she was preparing her fanny pack and her blank ammunition for the next scene. You agree that that's sounds like armorer work to you, not props work?
Yes.
Okay. And are you also aware, sir, that on the morning of the 21st, when the crew was waiting for replacement camera personnel to arrive, Ms. Gutierrez had approximately 3 hours to work on her preparation for the scenes that day?
I was not aware of that.
Okay, thank you.
If there was a scene going on inside the church at that time involving Mr. Baldwin and the firearm, if Miss Gutierrez Reed was not in the church, would you have expected someone to have called her back in?
I would, if there's a firearm on set.
Nothing further, Your Honor.
All right, thank you. Counsel approach. Next witness.
Your Honor, at this time, the defense rests.
Okay, thank you. All right, so both sides have rested. It's now my duty to give you the instructions of law. I'm going to read them to you, and then you will get a copy of the instructions, okay? The instructions I'm giving you are very helpful for the counsel to use in their closing arguments, okay? Which will follow. All right, so instruction number 1. You have heard all the evidence. It is now my duty to tell you the law that you must follow in this case. Instruction number 2. The law governing this case is contained in instructions that I am about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. Instruction number 3. The law presumes the defendant to be innocent unless and until you are satisfied beyond a reasonable doubt of her guilt, his or her guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. Instruction number 4. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide. Instruction number 5. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult with one another and try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence. Instruction number 6, each crime charged in the information should be considered separately. Instruction number 7, you must not concern yourself with the consequences of your verdict. Instruction number 8, you must not draw any inference of guilt from the fact that the defendant did not testify in this case, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 9. You alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in light of all of the evidence in the case. Instruction number 10. You should consider each opinion received in evidence in this case and give it such weight you think it deserves. If you should conclude that the reasons given in support of the opinion are not sound, or that for any other reason an opinion is not correct, you may disregard the opinion entirely. Instruction number 11. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude that it is unsound. Instruction number 12. For you to find the defendant guilty of involuntary manslaughter as charged in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. Hannah Gutierrez endangered the safety of another by handling or using a firearm in a negligent manner. 2. Hannah Gutierrez should have known of the danger involved by Hannah Gutierrez's action. 3. Hannah Gutierrez acted with a willful disregard for the safety of others. 4. Hannah Gutierrez's act caused the death of Helena Hutchins. 5. This happened in New Mexico on or about the 21st day of October 2020. Section 12A. For you to find the defendant guilty of involuntary manslaughter in count 1, alternative, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. 2. Hannah Gutierrez should have known of the danger involved by Hannah Gutierrez's action. 3. Hannah Gutierrez acted with a willful disregard for the safety of others. 4. Hannah Gutierrez's act caused the death of Helena Hutchins. 5. This happened in New Mexico on or about the 21st day of October, 2021. Instruction number 13. For you to find the defendant guilty of negligent use of a deadly weapon as a lesser included offense charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant endangered the safety of another by handling or using a firearm in a negligent manner. 2. This happened in New Mexico on or about the 21st day of October 20. Instruction number 13A. For you to find the defendant acted negligently in this case, you must find that the defendant acted with willful disregard of the rights or safety of others and in a manner which endangered any person or property. Instruction 13B. In addition to the other elements of tampering with evidence, the state must prove to your satisfaction, beyond a reasonable doubt, that the defendant acted intentionally when she committed the crime. A person acts intentionally when she purposely does an act which the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which she acts, the means used, or action number 14. You have been instructed on the crimes of involuntary manslaughter and the lesser included offense of negligent use of a firearm as charged in count 1. It is up to you, the jury, to choose the manner and order in which you deliberate on the crimes charged in that count. However, to return a verdict, you must follow the procedure described in the next instruction. Instruction number 15. To aid you in your deliberations and in returning your verdict, you will be provided both guilty and not guilty forms for each of the crimes charged in count 1. Unless you unanimously agree on a verdict, you should not sign a verdict form for that crime. Although you may deliberate on the crimes charged in count 1 in any manner and order which you choose, you must return your verdicts for each offense in count 1 in the order they are instructed. Under this procedure, if you unanimously find the defendant guilty of involuntary manslaughter, you should sign the guilty form for that offense and should not proceed to reach a verdict on the remaining offense in count 1. If after reasonable deliberation you do not reach a unanimous verdict on involuntary manslaughter, you should not sign a verdict form for that offense and should not proceed to reach a verdict on the remaining offense. You should only return a verdict on negligent use of a firearm if you unanimously find the defendant not guilty of involuntary manslaughter. If you unanimously find the defendant not guilty of involuntary manslaughter, you must sign the not guilty verdict form for involuntary manslaughter before returning a verdict on any other crime charged in count 1. If you unanimously find the defendant guilty of negligent use of a firearm, you should sign the guilty verdict for that offense. If you do not reach a unanimous verdict on negligent use of a firearm, you should not sign a verdict form for that offense. Instruction number 16. In this case, as to the charge of involuntary manslaughter contained in count 1, there are 4 possible verdicts. 1. Guilty of involuntary manslaughter. 2. Not guilty of involuntary manslaughter. 3. Guilty of negligent use of a firearm. 4. Not guilty of negligent use of a firearm. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You have the discretion to choose the manner and order in which you deliberate on this count, but you must return a unanimous verdict of not guilty on involuntary manslaughter before entering a verdict on negligent use of a firearm. You will first decide whether the defendant is guilty of the crime of involuntary manslaughter. If you unanimously find the defendant guilty of involuntary manslaughter, then that is the only form of verdict which is to be signed as to this count. If you unanimously find the defendant not guilty of involuntary manslaughter, then you should sign only the not guilty form as to involuntary manslaughter. If, after reasonable deliberation, you do not reach a unanimous verdict on involuntary manslaughter, you should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crime. If you unanimously find the defendant not guilty of involuntary manslaughter, you will then go on to a consideration of the crime of negligent use of a firearm. If you unanimously find the defendant guilty of negligent use of a firearm, then that is the only form of verdict which should be signed. But if you unanimously find the defendant not guilty of the crime of negligent use of a firearm, then you should sign only the not guilty form. If, after reasonable deliberation, you do not reach a unanimous verdict on negligent use of a firearm, you should not sign a verdict form for that crime. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of the crimes, you must determine that the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes in count 1, you must return a verdict of not guilty as to this count. Instruction number 17. For you to find the defendant guilty of tampering with evidence as charged in count 2, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant Hannah Gutierrez had a baggie of cocaine by asking Rebecca Smith to take it outside of Hannah Gutierrez's hotel room, or hid a baggie of cocaine by asking Rebecca Smith to take it outside of Hannah Gutierrez's hotel room. 2. By doing so, the defendant intended to prevent the apprehension, prosecution, or conviction of Hannah Gutierrez for the crime of involuntary manslaughter. 3. This happened in New Mexico on or about the 21st day of October, 2021. Instruction number 18. A firearm means any weapon which will or is designed to or may readily be converted to expel a projectile by the actions of an explosion. The frame or receiver of a firearm, any firearm muffler, or firearm silencer. Firearm includes any handgun, rifle, or shotgun. Instruction number 19. In addition to the other elements of the crime of involuntary manslaughter as set forth in instruction number 12A, the state must prove to your satisfaction beyond a reasonable doubt that 1. The death was a foreseeable result of Hannah Gutierrez placing a live round into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez's failure to perform an adequate safety check of the ammunition she loaded into the firearm. 2. The act of the defendant was a significant cause of the death of Helena Hutchins. The defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside events, resulted in the death and without which the death would have not occurred. There may be more than one significant cause of death. If the acts of 2 or more persons significantly contribute to the cause of death, each act is a significant cause of death. Section number 20. The state must prove beyond a reasonable doubt that the defendant's act was a significant cause of the death of Helena Hutchins. An issue in this case is whether the negligence of a person other than the defendant may have contributed to the cause of death. Such contributing negligence does not relieve the defendant of responsibility for an act that significantly contributed to the cause of death, so long as the death was a foreseeable result of the defendant's actions. However, if you find the negligence of a person other than the defendant was the only significant cause of death, or constitutes an intervening cause that breaks the foreseeable chain of events, then the defendant is not guilty of the offense of involuntary manslaughter. Instruction number 21. Now the lawyers will argue the case. What is said in the closing arguments is not evidence. It is an opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state has the right to argue first, the defense may then argue, and the state may then reply. Counsel?
Ladies and gentlemen, May it please the court. I want to begin by thanking you all for your time. I know that this has been a long trial, and I also understand that as jurors you find yourselves maybe a little frustrated. There's a lot of sitting around and waiting, and we appreciate your time. We appreciate the sacrifice that you make when you leave your jobs and your families and your other responsibilities, and you come to court to participate in a very, very important part of our justice system. So on behalf of the state of New Mexico, we thank you very much for your time. And as you can see on your screens, we end exactly where we began, in the pursuit of justice for Helena Hutchins. I want to start by just generally outlining Hannah Gutierrez failed to maintain firearm safety, making a fatal accident willful and foreseeable. And please keep in mind that omissions can also be willful. So if we fail to do something that we should do, and that failure results in someone's death, then that too can be willful. So I would ask that you keep that in mind as we move through some of the evidence and testimony that you have heard. I know that you have heard a lot, and I do not intend to keep you too long, but I do have to be thorough. I do want to hit some high points. So I do appreciate your patience. What we saw, the videos, if you recall, that were taken by production outfitters, they were taken on October 13th of 2021. What these demonstrate to you is that Ms. Gutierrez was unwilling to maintain proper firearm safety repeatedly. It's really important because this is not a case where Hannah Gutierrez made one mistake, and that one mistake was accidentally putting a live round into that gun. That's not what this case is about. This case is about constant, never-ending safety failures that resulted in the death of a human being and nearly killed another. So let's talk about all of the safety failures that we saw, and the reason that these safety failures prior to October 21st are so critically important to the analysis is because they go to foreseeability. And foreseeability is a very important element in this case. So as we can see here, our stuntman with his double-barrel shotgun, from watching those videos, what you understood is that Ms. Gutierrez did appear to, in fact, be present, because at times we saw her and at times we heard her. So she wasn't off doing prop duties. She was right there, and she never intervened. Gun pointed at a child. Gun pointed at Joel Souza directly at his back. Gun pointed up in the air in the direction of the stunt coordinator. Gun pointed again, apparently in the direction of Mr. Souza, the person on the far right. Gun pointed directly at Mr. Souza again. The firearm in the left hand of the stuntman who is facing. Firearm pointed directly at a minor child. Firearm pointed directly at the camera. Ms. Gutierrez, holding that same firearm with the muzzle pointed at her own face. This was unexpected. Ms. Gutierrez stood by and did nothing in between scenes when that stuntman, who had certainly been sent the message that he could do whatever he wanted with those guns, no one was going to intervene. The person tasked with intervening was not going to do it. That was clear. He hands the firearm to the child and allows the child to manipulate the gun before then, after a short period of time, perhaps thinking better of it and taking the gun. Firearm, I actually don't think in this photo that the firearm is pointed at the child. I think the firearm is, based on the angle of the camera, probably more pointed at this person right here. But there. We hear her, we see her, she does nothing. Absolutely nothing. This is some of the first evidence that we see where if something doesn't stop, if something doesn't change, she is moving in the direction of potentially a fatal incident, and that is exactly what happened. And I want you to recall Ms. Gutierrez's interview on November 9th when Ms. Gutierrez spoke of the accidental discharge with the other stuntman. Having a complete lack of understanding of her role in safety on this movie set. She's talking about Sarah Zachary, and she was like, well, yours just went off in there after you loaded it. And I said, yeah, well, I can't be responsible for every dickhead fucking stunt guy that gets a hold of the gun and doesn't understand the concept that it's hot. Her entire job is to be responsible for exactly that. And when she took this job, she agreed to that responsibility. There's no exception in the law for you're young. The exception in the law does not exist. The law treats everyone the same, and it must. What was the point to the testimony about the lever action rifle? Well, here's the point to the testimony about the lever action rifle. More negligence, more carelessness, more lack of attention to safety. She loaded a lever action rifle with dummy rounds that, by the way, according to the director, was completely unnecessary. Because yes, while it's true, this gun operates in a way where if a certain type of camera angle is hitting it, dummy rounds would be appropriate if the scene calls for loading or cycling. There wasn't a scene that called for that. So she just loaded a lever action rifle with dummy rounds and surprisingly put the wrong caliber round in the gun. That is absolutely an example of someone who is not paying attention, not taking their job seriously. I'll talk to you a little bit about some of the rounds that you've seen because it's critical to tracking the existence of the live rounds on this movie set. And we have a lot of time and effort tracking those rounds around that movie set, and we're going to show you that evidence right now. So the important thing to know is that the Seth Kenney dummies, which you are looking at right here, are patinaed. They are distinct. They have an antique coloring. They also have silver primers. These rounds did not come on that movie set until October 12th of 2021 because Mr. Kenney didn't have them, and if you recall his testimony, he was in Texas. So he had to get back, clean them up, and provide them to Sarah Zachary, and that took place on October 12th. This is just simply the primer side of those rounds. You can see that they're dark in color on the primer side, and they do appear to have silver primer. This is a photograph of the 3840 dummies. If you recall Mr. Kenney's testimony, the 3840 dummies came from Billy. And the important thing about this photograph is that none of those dummy rounds had silver primer. And silver primer is a very important piece of this puzzle. This is those same rounds on their side. You can see that they are shiny brass. We also know that they have brass primers. We just saw that. Based on Mr. Kenney's testimony, you know that they were 3840, but there was also some 4440 caliber rounds in that box. Well, let's stop. Okay. Let's take a moment to talk about all this testimony that you've heard about whether or not the live rounds found at PDQ, which are photographed there on the left, match the live rounds found on the set of Rust. You don't have to be a gun expert to look at those and see they simply do not match. Even though you could look at those rounds and fundamentally understand that they are not the same, the the sheriff's department sent them to the FBI for testing so that we could actually have some experts confirm what we can see with our very own eyes. Want to see them in real time? You have States Exhibit 79, you have States Exhibit 91. States Exhibit 79 is a disassembled live round from PDQ props. States Exhibit 79 is a disassembled live round from the set of Rust. You can look at them, you can see the projectiles are different, you can see that perhaps the primers are even different. If you recall, Ms. Popple indicated there were only 10 silver primered live rounds found at PDQ. The rest of them were brass. The other thing that you can just see with your eyes is the gunpowder in these is substantially different. It has a different chemical composition. So any argument that could ever be made in this case that Seth Kinney was the source of these live rounds, absolutely dishonest. Now, I'm going to ask you to take a walk in the weeds with me here, okay? This is a photograph of October 10th of 2021. You can see the color of the rounds at the top. Those are brass primered rounds. The rounds in the bottom appear to be lighter, and I would suggest to you, based on the totality of the evidence that we're going to go through, that you are looking at live rounds. And keep in mind, anything that you see on the set of this movie that is a revolver ammunition, prior to October 12th, if it has a silver primer, it's a live round. Because the silver primered dummies didn't come on set for 2 days after this photograph. Our comparison photo that Mr. Primo put together for us. And if you need it when you're reviewing the evidence and doing your deliberations or engaging in your deliberations, I have included it for you. But we're going to do a comparison here in a moment. Now, the importance of this photograph, still October 10th of 2021. There appears to be revolver ammunition in the background there at the top. 2 of those have silver primers. The problem with that is the silver primer dummies weren't there yet. But the live rounds were. Here's your close-up. It's absolutely undeniable. Is it blurry? Yes. Can you clearly see the difference? Absolutely. All of these photos that you're looking at were October 10th. Now, let's move to October 13th of 2021. I invite you to look at that photograph carefully and ask yourselves, which of these is not like the others? It's the third one from the left. Look at the shape of that projectile and look at the color of the brass. So on October 13th, Mr. Kinney's dummies have arrived on set. They are the only dummy rounds with silver primers, but they are patinaed in color. So when you look at this round, it appears to be a spot-on match for the live rounds, but unfortunately we can't see the primer in this photo, so we can't tell if this is a brass primered dummy. That's the reason that we watched thousands of videos and looked at thousands of pictures, because then we moved to the production outfitter videos from October 13th, the same day, and we're looking at that same gun holster that was provided to Mr. Baldwin. And there you see. Third one down has a silver primer. And now you know it is a live round. You know that because it's not a Seth Kinney dummy. If it were, it wouldn't have that shiny brass. So there's your live round. Seen it on October 10th. We've seen it on October 13th. And there's absolutely no way that the lighting is playing tricks on our eyes when we're looking at these enhanced photos, because you see it frame after frame after frame. Now let's move to October 5th. Erin Kuhn arrives on set. I think she was probably there long before the 15th. She is taking photos. She took approximately, as she testified, 9,000 photos. So on the 15th, there it is. There's your silver primer. It's just been moved to a different location in the holster because they're pulling dummy rounds from here, there, and everywhere and putting them in belts and putting them in guns and doing whatever they want to do. But there it is. It's right there on October 15th. If you think I'm stretching it, let's have a look at what we've got here. This is the gun belt that was assigned to actor Jensen Ackles. Because his gun belt was not a shoulder holster, we weren't able to find any photos or videos of it in the thousands and thousands and thousands that we reviewed, because they're always covered. There is the evidence photo of the Baldwin holster on October 21st when it is taken into evidence. You have a Seth Kinney dummy at the top. You have what the FBI determined to be a live round in the second spot, and then you've got 3 brass primered dummies. October 17th, October 21st. So the video that Mamie Mitchell laid the foundation for, she said that according to her notes, the filming was done on the 17th. Mr. Primo said that he believed, according to the camera, it was the 18th. Take whatever date you want. That's a Matt Kinney dummy at the top, live round next. You've got 3 brass primer dummies on the 21st, 4 brass primer dummies on the 17th. It is shockingly the same. And there is no question that this one right here was a live round. It was sent to the FBI and they confirmed. This is Ms. Gutierrez talking about her bringing these dummy rounds. I had a multitude of the ones with holes and the ones that you shake, so yeah. And I checked those all and I put them into 2 things. We start talking about boxes. Obviously, when she says things, she's talking about usually had JS on them. This is one my dad sent me, and mine are usually beat up pretty bad, like they're very dirty and gross. She's talking about the box and the styrofoam insert. The box and the styrofoam insert, she's saying, are dirty. Hers, the ones that she brings on set, are dirty. They're not new and clean like some of the other. Hancock asks her, this is the one that was or handed that you guys had said that you had pulled from. This is that moment in that interview where Ms. Gutierrez has already shown Hancock the photo from her dad, and an hour or 2 later, Detective Hancock decides that now is the time to show her the photo of the box of dummies she was pulling from that day, and it won't surprise you to learn they're a spot-on styrofoam insert from that box of dummies here in evidence, and the reason that we gave it to you so that you can actually look at it in real time and not look at a photograph is because it's kind of dirty and gross. It kind of fits exactly the way that she described it. But there are some characteristics of this styrofoam insert that are going to become more important. Any suggestion by the defense that somehow the box of dummy rounds that Ms. Gutierrez said she was pulling from was swapped out with something different is absolute nonsense. First of all, you know that because you can see the live rounds. If you don't think you can see them on the 10th, and you don't think you can see them on the 13th, and you don't think you can see them on the 15th, you know you're looking at one on the 17th and 18th. You know you are. So where does the sabotage theory go then? The 17th and 18th, the camera crew hadn't quit yet. Mr. Norvell wasn't on set poking around on the prop cart. Mr. Halls hadn't had an opportunity to spend any time with the gun. Moved directly from that cart right into Lieutenant Benavidez's patrol unit. They go from that patrol unit right into evidence at the Santa Fe County Sheriff's Department. And on November 9th of 2021, Hannah Gutierrez shows Detective Hancock, now Corporal Hancock, the box of dummies that she and her dad have. And if you listen to Mr. Kenny's testimony, what you understand is that the ammunition from the previous set, that being the old way, Hannah brought leftover dummies from that movie onto the set of Rust. And those 45 long Colt dummy rounds were provided by Thel. You are looking at, in this photo, is this styrofoam insert. This is the styrofoam insert that had the live round in it. This is the styrofoam insert that came out of the box labeled 45 long Colt dummies with the JS in the mouth together. Original evidence photo up here from October 10th. You can see this distinct sort of cut in the styrofoam on that insert that is sitting on her leg on the 10th. You can see that the hole in the styrofoam in the second to the right at the top is dirty. You can see a little bit of grime right there. And you're going to take it into evidence and you can look at it closer. You're going to see that there's some damage to the styrofoam separators between these two holes. You know, it's right there. There's a little bit of damage to the styrofoam separators down here. You can see it in the photo on the right. You can look for yourself. It is right here. And what do you know? That silver primered round from October 10th is sitting in the exact same position that it was found on October 21st when the Sheriff's Department collected this box, took it into evidence, and ladies and gentlemen, we call that circumstantial evidence, but that's a mountain of circumstance. Top assistant duties versus armorer duties on October 21st of 2021. Let's focus on that day. And listen, I'm not here to tell you that Rust Productions did the right thing when they hired on a part-time armorer and asked her to also spend her time doing props. I think everybody who has testified has said that was a really bad idea, and that's probably part of the reason that they're being sued by a whole bunch. But on October 21st, this was simply not the case. It was not the case on that day. She had 3 hours in the morning waiting for the camera crew to arrive. She had every opportunity to go through that box of dummies, that only had like 30 rounds in it. How long does it take to pull the round out of the box, shake it, and if it doesn't shake, look to see if it has a hole in it, put it back in the box, and do that to each and every one of them? How long does that exercise take? 10 minutes max? That's not hard. The other thing that is very important is Ms. Gutierrez didn't get pulled out of the church because she had to go focus on prop duties. She left the gun in the church contrary to all the industry standards for armorers on movie sets, for firearms safety on movie sets, and she went back out to her cart so that she could start doing other armorer duties. She's getting her fanny pack filled up. Well, we've seen that. She's filling it with blanks. And we know they're about to do a turnaround. They're going to do this quick insert with Baldwin. And then they're going to do the shoot scene, the gunfire scene where they're using blanks, and the law enforcement have come into the church and there's a shootout. So she goes to get ready for it. She just leaves the gun in there. As you heard from many witnesses, she would leave guns unattended all the time. There was nothing unusual about October 21st that caused her to be unable to stay in the church to properly perform her duties. She leaves the gun. She goes back out because, for some reason, with the 3 hours of free time that she had in the morning, she didn't get her fanny pack filled up. She didn't get herself ready for that turnaround, so she leaves the gun. Everybody's heard, armorers don't leave. Let's move over to our tampering with evidence. How is getting rid of a bag of cocaine tampering with evidence related to involuntary manslaughter? Well, on October 21st, 2021, the shooting occurs, the incident occurs. Ms. Gutierrez understands that someone has been seriously injured. She does not yet know that that person is not going to live or has already died. She gets interviewed at the Santa Fe County Sheriff's Office. I will say, surprisingly, 2 occasions after this incident where a helicopter had to come in, ambulances had to come in, Ms. Gutierrez, on 2 occasions after that incident, spoke about her concerns about her career. Wow. That gives you an idea that you are dealing with someone who is not particularly concerned about the health and safety of others. And her job was to be concerned about the health and safety of others. But on that day, she's just thinking about her. She put a lady in the hospital. A man in the hospital asks to be escorted to the bathroom. Corporal Hancock agrees to do that. And we have her on video on the way there expressing dismay about how this will affect her career. Ouch. After the interview, Hannah goes back to her hotel. Rebecca Smith goes to Hannah's room. She's been summoned by some other folks to try to sort of sit and visit and give Hannah some support. So Rebecca Smith goes to her room, and Rebecca Smith is the person that tells Hannah that Helena Hutchins has now died. You have to understand, in the mind of Hannah Gutierrez, this investigation went from this big to this big. Because the difference between shooting someone and them living and shooting someone and them dying is a really, really big difference. So she is told by Rebecca Smith, investigation just got giant and very, very serious. So after receiving that information, she offloads this bag of cocaine to Rebecca Smith. Rebecca Smith is a lady that's lived a life. She's used cocaine before, many years previous, but she's used cocaine. She knows what it looks like. She knows how it's packaged. And because she's a former addict, she tosses it in a trash can. When Mr. Bowles gets up here and says, I can't prove to you that it's cocaine, remember that when people destroy evidence to avoid prosecution, you don't have the evidence that they destroyed, they got rid of it. So I don't have to prove to you by some scientific drug test. I don't have to send that to the lab and get it tested. It's gone. That's the point to the charge. Let me digress a little bit and run through a couple of things with you. What's all this testimony about this inertia puller? And how does that play into everything? Well, as you heard from Mr. Haig, an inertia puller is a device designed for one task. It disassembles live rounds. That's what it does. Somehow I think the defense got confused about what our potential theory was that we had a theory that Ms. Gutierrez was turning dummy rounds into live rounds. That was never our theory, because that would require quite a bit of equipment. There's no question. But to do the reverse is a whole lot. If you're out of dummy rounds or you're running low on dummy rounds and you've got some live rounds around, you could probably turn a you could turn a live round into a dummy round in 5 minutes. Why does an armorer on a movie set bill for an inertia puller? Well, obviously. Now, let's talk about the OSHA investigation. OSHA doesn't find any wrongdoing with individual employees, only employers. That's their job. They're just an agency that maintains workplace safety. Mr. Genoway confirmed when he was on the witness stand, it's true his memory was a little bad and Mr. Lewis had to refresh it for him, but he confirmed that Hannah's conduct on the set contributed to their findings that this was not a safe workplace. Please keep in mind that the OSHA investigation is not a criminal investigation. Critically and surprisingly, OSHA never interviewed Gabrielle Pickle. This is critically important because if they had interviewed her, they would have known the following things. Hannah was granted 10 armorer days out of the 12 filming days, not 8. That was right there in the cell phone records. The training days, when Ms. Gutierrez is sending those messages saying, I want more training time, training days. She's not saying these actors, these adults need more training time. She specifically requested additional training time to train the child, and it was refused because, first of all, it's a major liability issue, and second of all, the child was never going to fire a gun. So when she asked for the additional training days, they were denied. That's not the reason Helena Hutchins is dead. In mind, Gabrielle Pickle had a meeting with Hannah and offered her additional assistance so that she would be able to perform her duties effectively. She offered assistance from some of the other folks there on set to try to give her some relief. And keep in mind that on a movie set, the armorer has autonomy with regard to gun safety. The OSHA finding that Rust Productions failed to properly supervise her is surprisingly incorrect because the armorer has no supervisor when it comes to weapons and gun safety on the movie set. Mr. Halls is just there to be a second pair of eyes. That's it. Now, I think there can be no question that Rust Productions was more than negligent when they hired Ms. Gutierrez because she was not anywhere close to being qualified. In fact, if you recall, Gabrielle Pickle, to her credit, tried to get Ms. Gutierrez to implement a check-in and check-out system because 2 people had complained that there was a shotgun left unattended. People on the set were complaining about her. They went to production and said, hey, she's not supposed to do that. You can't just leave real guns laying around. So Gabrielle Pickle goes to Hannah Gutierrez, asks for a check-in, check-out system. Hannah Gutierrez says no. Hannah Gutierrez says it's too difficult, it's too much trouble. Gabrielle Pickle didn't prevent her from being safe. In that instance, she did the opposite. She tried to improve firearm safety on the set, but keep in mind, the armorer has autonomy. So Gabrielle Pickle is not Hannah Gutierrez's boss when it comes to firearm safety. Ms. Gutierrez gets to do what I can only imagine that after this chain of cases, the defense has taken a shotgun approach to this case. Seth Kinney is to blame. Well, no evidence of that. Sarah Zachary is to blame. No evidence of that. Dave Halls is to blame. He shouldn't have taken the gun from her. and he didn't do a good safety check. Well, she is the autonomous decision maker with regard to gun safety. It's not that Dave Halls shouldn't have taken the gun from her, it's that she shouldn't have given him the gun and then turned around and walked away. The defense. Alec Baldwin is to blame for acting like a prima donna on the movie set and bossing people around. This is Hollywood, for heaven's sakes. I would imagine that's relatively common. Don't get me wrong. I'm not saying that his conduct was right. I am the person who indicted him. Alec Baldwin's conduct and his lack of gun safety inside that church on that day is something that he's going to have to answer for. Not with you and not today. That'll be with another jury on another. Brian Norvell, the gentleman who goes and gets the prop cart and wheels it over and then puts his hand over the crime scene tape and picks up that dummy round and shakes it. You heard Mr. Bowles ask some questions that are intended to make people think that Mr. Norvell either took something off the prop cart or planted something on the prop cart. Well, keep in mind, he doesn't have to plant live rounds because we've seen from the photographic evidence, those are there. They're floating around already. So live rounds were on set. They were not planted by Brian Norvell. But this man is not a mystery to the state or the defense. I made him come in and sit down for a 1.5-hour interview so that the defense could ask him any questions they wanted, and they asked him none. Not a single question. So what that means is that this is just all smoke and mirrors and deflection. They don't want the truth. We know the truth. You have seen it throughout this trial. And I will remind you that during one of the heated objection exchanges between myself and Mr. Bowles, you heard Mr. Bowles cry out that he was looking for the truth. Listen, I can bring a horse to water, but I cannot make him drink. If you want the truth, I'll bring the guy in. I'll make him available for you to talk to. Ask him some questions. Must have been that disgruntled camera crew. You mean the people who believed that safety on set was being compromised to such a degree that they left? That decision may very well have saved their lives. So, the $60,000 question in this case, who brought the live rounds on set? You know the answer to that. I know the answer. I'm not telling you that Hannah Gutierrez intended to bring live rounds on set. I'm telling you that she was negligent, she was careless, she was thoughtless. She brought them on set, and you know from the testimony you heard, Sarah Zachary never saw her shake a dummy round. Dave Halls never saw her shake a dummy round. And shake those dummy rounds. For all we know, those dummy rounds were floating around the set of The Old Way, and Nicolas Cage is lucky to have walked away with his life. Why does it matter that she brought live rounds on set? It goes to foreseeability. She had six live rounds on that movie set. The earliest date that I can track them for you is October 10th. We know that they were there from the 10th to the 21st. 6, and she failed to ferret them out for 12 days. What that means is that she wasn't shaking any dummy rounds. She wasn't testing anything. None of that stuff that her lawyers want you to think was so difficult. None of it was happening. It didn't happen the entire time. She didn't find any of it. Folks, if she's not checking the dummy ammunition during the pendency of the filming to make sure that those rounds that are designed to look like live rounds are in fact dummy rounds, this was a game of Russian roulette. Every time an actor had a gun with dummy. Sadly for Ms. Hutchins, her camera crew walked off set that morning, and that required her to go into the church and operate the camera. That's what she was doing when the live round that Ms. Gutierrez put in Mr. Baldwin's gun was expelled from that firearm and went all the way through her body. No one told Ms. Gutierrez to leave the church. No one called her out of the church. There wasn't a COVID protocol in place that prevented her from being in the church at that moment. You know from the production outfitter videos, she didn't care about her job. She let it all go. Mr. Bowles is going to argue to you that if Mr. Halls had just called Ms. Gutierrez back into the church, she would have done an additional safety check and that live round would have been found. Well, for heaven's sakes. We all know that if she had been called back into the church for an additional safety check, nothing would have changed. Her safety checks didn't consist of pulling the dummy rounds out of the cylinder, shaking them in front of the actor and the assistant director, showing them that they're dummy rounds, and putting them back in. No one ever saw her do that one single time, even though that's industry standard. And the reason it's industry standard is because you can't tell a dummy round by simply spinning a cylinder and looking at the primers unless they are dummy rounds without primers. And that's kind of an interesting fact. We know that 6 dummy rounds without primers were not loaded into that weapon because one of them turned out to be live and very clearly had a primer. Interestingly, though, she had 5 dummy rounds without primers in her pocket. All she had to do was put those in the gun. Make sure that the 6th one either rattles or has a hole in it, and she's good to go. Because now, when the cylinder gets spun, you can see 5 of them without taking them out, that they don't have primers. They were in her pocket. And I am going to have another opportunity to speak with you, and when I speak with you last, it won't be as long, I promise. And we will talk about some of our jury instructions then. But I do want to address some of the testimony from Dr. Gerald from OMI, because Mr. Bowles is likely to make an argument that there was some sort of medical negligence that contributed to Ms. Hutchins' death. And I want to talk to you a little bit about Dr. Gerald's. The lethal injuries, blood loss from the wound. That was the primary lethal injury. Her blood was leaking into her abdominal cavity, and a lot of it. And you saw those photographs. You saw the photographs of her clothing. There was a lot of blood. So the first lethal injury that comes from the gunshot is blood loss associated with it. And the second one, if you recall from Dr. Gerald, the wound to the lung was also a lethal wound. Keep in mind, that bullet went into her body, it went through her rib, it severed her spinal cord, it punctured her lung, the back of her shoulder, and a few hours later, Ms. Gutierrez is telling Corporal Hancock that she's worried about. I think that person would have done a satisfactory safety check if she had been called back to the church. I am here to tell you that I strongly, astonishing lack of diligence with regard to gun safety is without question a significant cause of the death of Helena Hutchins. Did Mr. Baldwin also contribute when he pointed the gun at people and pulled the hammer back, and regardless of what he said to George Stephanopoulos, pulled the trigger? Yes, he is. And again, we'll deal with that another. Don't escape accountability when you load a live round into a prop gun. Tell the crew that it has dummy rounds in it, hand it off to an actor, and leave the room because he manipulated it. That's the whole point. That was the whole point to him having it. Of course he was going to manipulate it. It's foreseeable. Everything is so completely foreseeable. Imagine I hand you a gun and I tell you that it's basically empty and I walk away when in fact I put live ammunition in it. You think an accident might happen? You think that accident is foreseeable? And listen, let's remember some of the testimony from Mr. Carpenter. Control is how we enforce gun safety. We do it with control. When she loses control, which she did repeatedly, anything goes. Anything goes. I'm going to complete the majority of my closing argument. With regard to the facts, the next portion will be with regard to the law. When I come back after Mr. Bowles has had an opportunity to address you, we will be asking for justice today for Helena.
If it's about a bathroom break, we're going to take a bathroom break.
Okay.
Okay. So please don't talk among yourselves or anyone else about the evidence received here in court. Thank you. We'll be back at 10 of. Okay? You may be seated. Mr. Bowles?
Thank you, Your Honor. Yeah, please, court, counsel. Ladies and gentlemen of the jury, I want to start also, as I did when this began, which I want to sincerely thank you for your time and attention and all of your work on this case. It's been hard. It's been a long case, and I want to thank you first. On behalf of Ms. Gutierrez Reed, who this is extremely important for her, this case, and this is her day in court. And it's extremely important that the government rule out every reasonable doubt that there is in this case, because that is our standard in this country. Reasonable doubt is a concept, meaning if you have any reasonable doubt, if you have a reasonable doubt, we cannot convict people in this country. That's how it's set up. Because of that, the burden is on the prosecution, always stays on the prosecution, and so they have to rule out all of the reasonable doubts. In this case, and I'm going to talk about a lot of the evidence soon, but I just want to start with a summary. The prosecutor just presented to you a series of pictures, and those were the pictures they paid the guy $10,000 to enlarge. And they went through the pictures and they tried to show that there were silver primers, and this is going to be definitive evidence that these live rounds had to be on site at a particular time. Let me tell you why there's reasonable doubt, number one, that they will never be able to rule out in this case. Sarah Zachary threw away rounds. She unquestionably threw away rounds after the shooting. It's undisputed. We have no idea what those look like. We will never have an idea what they look like, and that will never be able to be overcome. That one fact alone prevents that entire picture setup that was just shown to you from being accurate, from being real. Because we have no idea what those other rounds, whether they had silver primers, whether they were dummies, whether they were other types of dummies, what they look like. We have no idea. Fact two on the pictures. Seth Kenney told you he had gotten live rounds from Thel Reed that went to the 1883 set. Those live rounds were three types. There were three types of bullets. He then brought back around 125 of those of the three types. Now, the ones that the state seized, the prosecutors made a point of saying these don't match the live rounds. However, we don't know what he had, because they waited a month to go get them. It was over a month when they searched. And when Mr. Kenney brought in the rounds, he had been talking to the investigator about what was going on in the investigation. So we're never going to have an idea as to what Seth Kenney had and what he provided, because he also told you in this trial he had no inventory system. He had no idea what was coming in and going out of his place. The place was a wreck. Looked like a train had hit it. There's no way for somebody to really understand what they're putting in, what they're going out. And so he also said there were things that went onto the Rust set that he hadn't inventoried, hadn't invoiced. He said that there were things that put on there that he didn't have invoiced. So here's the problem with that. We do not know that Seth Kenney only had those patinaed rounds. That's reasonable doubt. That's coming right from the government's witnesses, from Mr. Kenney. That part is unreconcilable. There is a reasonable doubt that we'll never leave this case on those 2 points, on the pictures and the live rounds. Now, Ms. Morrissey calls it dishonest for us to raise a question about Mr. Kenney. And I submit it's not dishonest at all, because they have the burden to investigate every possibility, every aspect, as anybody in Ms. Gutierrez Reed's place would deserve and would want, because their life is on the line as well on felony charges, and it's the government's duty to rule out all these other things. Far from dishonest, what it is thoroughness, competence, finding what happened with Seth Kenney, taking his fingerprints, taking his DNA, going through and searching earlier, doing that investigation, and finding out if indeed there is another possibility that they ruled out right away and they never wanted to look into, because they rushed to judgment on Ms. Gutierrez Reed from the very beginning. They singled her out on that set. They put her in a cop car, whether she asked or whether they put her in. She's in a cop car and she never leaves custody until after her statement. They singled her out and they rushed to judgment on her, and that's what you've seen ever since. Ms. Morrissey says, and a camera crew, and she mocks things that we raise as possibilities on the idea that none of it can be possible except Ms. Gutierrez Reed is guilty. That is the only thing that can be possible because I say it. It's not how it works. Ms. Morrissey said she indicted Mr. Baldwin. I indicted Mr. Baldwin. Actually, I think it's the state of New Mexico, an individual person. Also sat there when Ms. Zachary was on the stand, and Ms. Zachary, I'll remind you, got an immunity agreement. Ms. Zachary was promised she would never be prosecuted. And Ms. Morrissey stands up and says, there's no evidence against Ms. Zachary. Well, then why was she given an immunity? Why would she need immunity if there's nothing against Ms. Zachary? Immunity agreement. And then she's told on redirect examination by Ms. Morrissey, remember, if you don't tell the truth, I can prosecute you. I will prosecute you. So Ms. Zachary doesn't tell the version of the truth that the government believes is true. We saw the threat in live court. Trust some of the witness testimony in this case, and that will raise a reasonable doubt as well, I submit, because of things like that. Because the lead investigator admits that she practiced her answers and questions with the prosecutor. That's something you can consider. Are you hearing everything? Or are you hearing a one-sided version that fits the narrative that Ms. Gutierrez Reed has to be guilty because we picked her out first, and it's got to be her? Can't be Mr. Kenney, can't be anything else, any other possibilities. Sarah Zachary has nothing to do with it, even though we know unquestionably she threw away rounds after a shooting. That's undoubtedly going to be evidence, but there's nothing on her. These boxes. The idea that the boxes match. We heard testimony that these rounds were loaded in and out of these boxes daily. Nobody knows what was in them on the 13th, the 16th, the 21st, because the rounds were put in, they were taken out, and they were put in different boxes. So the boxes really don't matter. There's reasonable doubt all over the place to the boxes because we don't know what was in them 3 or 4 days before. It doesn't matter who brought them. The boxes are interesting because the government wants to match up the two, and they want to show the pictures that match, yet all the ones from PDQ Props have the same label, same font. They're from Joe Swanson. So those boxes are similar to the ones on set. So that part is is not conclusive as well. The other part, when the government shows you video and video of video only on the 13th and says Ms. Gutierrez Reed was lax on safety. Well, again, you're seeing videos from short snippets of time on one day on an entire movie set, and then you're not seeing what Ms. Gutierrez Reed may have done right after the clip. You're not seeing what might have happened right after that. The other thing that strongly rebuts all of the safety points Ms. Morrissey is pointing out about Ms. Gutierrez Reed is OSHA. Now they try to downplay OSHA, but OSHA is a separate, independent state and federal agency that did a full investigation into the responsibility for safety failures on this set. And you can evaluate the credibility in your minds of Mr. Montoya, who took the stand, and how you thought he testified, whether you thought he was thorough and how he answered questions. He interviewed quite a few people, and he reviewed a lot of information. Their conclusion after that was done was that production was responsible. He said the root cause was production adopted a safety plan, and it ended at the word adoption, because they didn't do anything after that. They didn't respond to complaints that there were safety concerns. They didn't allow for more training and take the time to do that. They did not respond to the negligent discharges and deal with that. Mr. Halls talked to one of the guys briefly, and that was all that happened. So you got a set that they're not allowing time for inventory for the armor. They're not allowing time for them to clean their weapons or deal with their weapons. This is management. You just heard Mr. Pesh state that the first assistant director is the primary person for safety on that set. Dave Halls has been doing this 30 years. Somebody doing it 30 years has a responsibility and duty to step in when there's safety things going on, and he's on several of those videos. He has a responsibility to step in and say, hey, we're going to stop this. We're going to slow this down. We're going to have meetings. We're going to have additional safety training, and we're going to address this. Ms. Gutierrez Reed, come over here. We're going to do this, and we're going to talk to people. She also can come in and talk about that. And on those videos, they're both on the videos. But OSHA found, because of the lack of support, because she's a part-time armorer, because she's not full-time, because there's not two of her, as Mr. Carpenter said, 2 is 1 and 1 is none. Well, here we didn't even have 1. We had a half. So she's trying to run around and do various things. She's a half a job on a set with over 20 guns, and they want to lay the complete blame on her in this case, as opposed to OSHA, who investigated as an official agency and made an official determination that this was production and management that was responsible. That's important. That's an important finding, because they said all of this was caused safety-wise by management. As Mr. Sousa told you, the buck stops with production. The buck stops with production. As in any organization, it starts at the top. You don't go and take one of the lowest people on the call sheet after something bad happens, after the whole management team has just thrown safety aside in favor of money, in favor of speed, in favor of profit. You throw all of that aside, because at the end, you've got a convenient fall person. You got a convenient scape. And she may not be the armorer on some days. She's a props person, but she's certainly the armorer when everything goes bad. You know why? Because despite OSHA's findings that they were responsible, production, the guys that you saw come in, the producers, the big guys, they want to sail off into the sunset and go on about their business, finish the movie, make the money, because they've got the convenient fall person sitting right here. And all that has to happen is everybody has to gang up. Everybody has to have their talks after this happened and blame Hannah. So it has to happen. That's what happened in this case. You had a production company on a shoestring budget, an A-list actor that was really running the show. He was directing people in those clips, telling the camera person where to go, telling the armor where to go. And then you had a situation where at the end they had somebody they could all blame. It didn't work out with OSHA because OSHA didn't buy it. OSHA said it was the higher ups. So here we are in a criminal court where the government tries to pin all of it on Ms. Gutierrez Reed. And it's just not the truth. It's absolutely right. We do want the truth. We want the truth and all the facts that were found by OSHA to be considered. We wanted all of the facts that you don't have in this courtroom to be considered, because that's the only fair way to do it, to resolve all reasonable doubt and to rule it out. If you don't have all the evidence, you can't rule out all of that. We talk about foreseeability, and I want to play this. I remember that. That was the scene where Mr. Baldwin runs up the hill and cut is yelled. And right after cut is yelled, he shoots. That's, I submit, reasonable doubt, and I'll tell you why. Because Mr. Baldwin went off script. He chose to fire after cut was called. And you're going to see where he does later do the same thing in this tragic shooting. Mamie Mitchell told you on the stand, the script supervisor, that it was not in the script for Mr. Baldwin to point the weapon. Not in the script for him to point the weapon. And we have to be very careful with facts when we're considering a criminal case and the beyond the reasonable doubt standard. That's extremely important, because Ms. Gutierrez Reed, nor anybody else, knew that Mr. Baldwin in that moment was going to point the weapon right at Helena and Mr. Hutchins and Mr. Souza and do what he did. That is the concept of foreseeability. Now, Ms. Morrissey gave you an example of, if I hand somebody a firearm and it's loaded, and then they go and do something with it and it hurts somebody. But here, what we had, she did not know Mr. Baldwin was going to do what he did. No one, first of all, called her back into the church that he was using the gun at that time. She had given it to Halls to sit in the church. Mr. Halls then gave it to Mr. Baldwin, and that is the conclusion of the lead investigator. That was what Baldwin said, and that is what Ms. Gutierrez Reed said. So Halls hands it to him. No one calls her back in to let her know Baldwin is doing that blocking scene. She doesn't know that's happening. The medic said she did not hear anybody call that out, first team, over the channel. So that's not getting put out. So Baldwin's doing another audible like he did on this video that you just saw. He's going off script. That defeats any idea that that was foreseeable to Miss Gutierrez Reed. If she doesn't know what's happening, she can't foresee it. That's a big part of the instruction. The other part I want to talk about foreseeability and where this matters is live rounds. Now, live rounds in this type of situation has not happened in Hollywood. In the 100 years of Hollywood, this has not happened in a situation like we saw in this case. No one on that set foresaw, knew, or thought that live rounds were going to be on that set. No one. You did not hear one witness in this case. Even Miss Morrissey said there was no evidence that Hannah knew about live rounds coming on, or this was done. There's no evidence of that. Nobody thought live rounds were going to be on set. Mr. Souza told the doctors he couldn't believe it. He argued with them because it was inconceivable that live rounds would appear. Because of that, when you read the jury instructions, there's a concept in the involuntary manslaughter of an element of willful disregard of the rights of another. That word willful, and I'm going to go over it soon, means purposeful. That you willfully do something, you purposefully do something. What's impossible for the government to prove in this case, and gentlemen, I'm going to talk about willful more in a moment when we get there, but it cannot be willful if Hannah does not know there's live rounds, and nobody did. So she did not do something willfully, knowing that Baldwin could foreseeably hurt somebody with this firearm, because she didn't know it was live. And let me give you an example. It's akin to a nurse, let's say in a hospital, who the pharmacy mislabels a drug. And let's say it comes to her and somebody's ordered it be administered to a patient. She then administers it not knowing that it's a fatal drug of some other type. The pharmacy's mislabeled it. The patient passes. It's the same situation as we have here, where the government would be saying the nurse committed involuntary manslaughter. No, that's not true, because she did not know what happened. It's like a long time ago when the Tylenol capsules were laced with cyanide, way back in the 80s. There was no prosecution of the pharmacies that didn't know about this, that were tainted by it. It's the same type of situation we have here with the nurse. Miss Gutierrez Reed did not know there were live rounds, and she was entitled to rely on production buying dummies and the boxes labeled dummies. She's entitled to rely on that, and that reliance is reasonable. So she cannot foresee a live round. I want to talk next about Miss Gutierrez Reed's statements to law enforcement. You saw her first statement. She didn't have an attorney. She did waive her rights and answer her question. She had not been advised at that time. Miss Hutchins had passed. And she came in a second time and answered all questions. The reason why I say that is she was cooperative. She was trying to assist in what this investigation, what they were investigating. Now, Corporal Hancock never fully investigated the source of the live rounds. And she told you that she focused on people on the set. So again, in ruling out reasonable doubt and where those live rounds came from, we have not done that in this case because there was never a full investigation as to the source of the live rounds. Let me give you an example. The state never called Joe Swanson. And it's kind of remarkable because Joe Swanson was the original source of where these came from. He's also the JS on all the boxes. So the idea that the person where it originated, you wouldn't call that person and get some more information is interesting. But more than that, it leaves a huge hole in the origin of the live rounds. Let me tell you what else it did. Seth Kinney's fingerprints and DNA were never taken. Seth Kinney talked to Corporal Hancock 40 times or more. They supplied information back and forth. And he starts making you wonder about what's going on and why I'm called dishonest for raising the possibility that maybe Mr. Kinney was the source. Because he's pretty tight with law enforcement in this case, obviously. They don't do a prop search warrant until 6 days after the incident, and that was Corporal Hancock and the rest of the sheriffs. They don't search Mr. Kinney's business until over a month after. They never asked the FBI to check live rounds for fingerprints or DNA. And so we will not know if Mr. Kinney's fingerprints or anybody else's would have ever appeared on those live rounds on set because they didn't get that. Ziegler, I want to tell you a little bit, remind you a little bit about his testimony, and that's Mr. Ziegler. He talked about Baldwin's revolver being single action. You have to cock it and then every time you want to shoot it. He testified about breaking that firearm. They actually destroyed the firearm after testing that was approved by the sheriff by hitting that with a hammer. He talked about that you can't determine a live round from a picture. And that's the other point. It's important to consider when considering the picture analysis. Now, the Latin print examiner, examined various things, but she did not examine anything Seth Kinney-wise. There's no analysis on the cartridges from the prop cart, and found 8 FBI employees. Mr. Gillette on the the powder testing. Only tested 11 rounds from Seth Kinney. Again, we know that he brought back 125 from the group that went to 1883. And I also want to remind you about 1883, some of those were Starline brass rounds. And some of those, he said, had silver primers. So when we get to the set, the live rounds are Starline brass, and they have, it's a continuous chain that could have been traced from They'll Read all the way to Seth Kinney, all the way back to the set. But they did not do that thorough investigation, and that's reasonable doubt. They have not ruled dummies. Again, I submit this is another area of reasonable doubt. Witnesses testified this set contained a dangerous mix of dummies. They were dangerous because it was impossible for the armor and prop master to hear and rattle all of the dummies, especially under pressure, rushing, and noise on the set. You saw there was a lot of wind that day on the lapel. There's people running around. There's, I think at one point somebody said 200 people. There's all kinds of things going on. And despite that, Mr. Haig indicated in a quiet office he could not hear one of the dummies when it's rattled. That's dangerous because when you're trying to do it quickly, when there's a lot of noise, it may be a dummy, it may not. You can't hear it rattle. Seth Kinney, again, mentioned in this case that he always rattle tested his rounds, and he made sure they're dummies. He told you all that. Well, the problem, even the box that they say was Seth Kinney's and the rounds that came out of it, there was one round, if you remember, that was gunked, and it didn't shake. That round had to be sent to the FBI to be broken apart and to be checked to see if it was live. So if he truly is that thorough in shaking, he missed that round. The producers, they had oversight over the budget team. They didn't know where the funds were set aside for the armor. They were on location for filming, and they were fined the statutory maximum by OSHA for managerial safety. And OSHA found that the management team are the ones responsible. And yet we're here with Ms. Gutierrez Reed, the person on trial for the felony. Ellen Schaefer was the medic on set. If you recall, she did not have chest seals. She, I think, was doing the best she could with the equipment that she had, but she didn't have the complete equipment to deal with a gunshot wound. She also indicated she never heard anyone call out use of a gun before the fatal shooting. Mamie Mitchell, I touched on this earlier. Most important thing Miss Mitchell said was that it was not in the script for Baldwin to point the firearm. That goes directly to the element when you read the jury instructions and you all go back in to deliberate. That goes to foreseeability and whether or not anybody can foresee the moments Mr. Baldwin pointing the gun, using it as a pointer. He's up on the hill shooting after cut, and then he's shooting, pointing the gun when he's not. David Halls was the first assistant director, as you remember, and he was in charge of overall safety. Now he got a misdemeanor. 6 months unsupervised probation, even though he was in charge of overall set safety. He never raised any concerns, and in fact, I think he said Hannah did a great job as armor. He indicated he did not hand the gun to Baldwin, but the sheriff contradicted this, so did Hannah, and so did Mr. Baldwin. And that was essentially Mr. Hall's testimony. Sarah Zachary, I remind you, she threw away rounds on set after the shooting, took items off the prop card. She worked for Seth Kinney, and she texted and called him right after the shooting. One of her texts, she indicated she had said she was talking to Alec Baldwin and trying to keep her fat. She mentioned that she had loaded firearms on set. She picked up ammunition from Kinney at PDQ. I'll remind you in the testimony that Sarah Zachary and Hannah Gutierrez Reed went to Kinney's place before production started, and he had given them ammunition, leathers, and firearms. So again, we don't know exactly what Mr. Kinney may have supplied to this set because it's not inventoried, it's not all in. Also remind you about Sarah Zachary when you're considering her credibility and her testimony. She had the text where she wanted Hannah to go to jail, and she's given complete. Seth Kinney, again, I mentioned this, he supplied the leathers, guns, and ammo before arrest began. He had no inventory system, and we attached some pictures to the right that you can look at in the jury room about his place. It was an absolute mess. There was stored live ammo in the bathroom. And one of the things I think was important to remind you of is he actually called Joe Swanson and had a conversation with him. And after he gets off the call, his first words are shit, shit, shit. So that's something as an investigator you would think after he does that, maybe I should call Joe Swanson and see what's happening. See what that reasonable doubt has not been ruled out. I went over this on the 1883 set, and he brought 125 rounds back. Carpenter, I want to remind you, he was the state's expert armorer. One of the most important points he said was 2 is 1 and 1 is none. And here we didn't have a properly staffed armor on it to the Luke Hague. He said the live rounds on set were reloads. He could not hear the dummy rattle in the quiet office, and he said Mr. Baldwin violated basic safety. Ann Kuhn, you may remember, was the photographer. She said the armor was checking guns before when she was present. And she also made a comment about Mr. Baldwin, that on the day she was taking questions, I believe she said on the 21st, he told her to get out of his personal space and said something in a manner that kind of goes along with how he was on the set. Mr. Souza was kind about it. He said he had a strong personality, but you can see it in the videos, and you can see how Mr. Baldwin... Rebecca Smith, I want to talk about the tampering. She said that she hadn't used cocaine in 31 years. She saw a baggie inside a baggie for approximately 5 seconds. She didn't know if it was cocaine or meth or something else. Now, she admitted at the end she was guessing. And we also know that the substance in the baggie was never tested. And so the only evidence you have of narcotics in this case is a guess. Now, Ms. Morrissey in her closing indicated that, well, of course we don't have the evidence. The whole thing is throwing it away. Well, you have to prove first that it was evidence. So in a normal tampering case, when, let's say, a firearm's thrown away, and we know a firearm was used, and somebody throws a firearm away, we know that was a firearm. So we know that would be evidence in a case involving a shooting. Here, we have an unknown substance. Again, they have to rule out all of the reasonable doubt by that. It's not enough to say it's probably something under a criminal standard. It's probably cocaine in that bag because Ms. Smith says it is. If it even happened, we don't even know this happened. The government hasn't established that except through her testimony. We don't know if there was a bag. We don't know if this actually was passed. And that's their burden. Let's say it did happen, that you believe it did happen. It's not enough to say what was probably in that bag. They have the burden to rule it out beyond a reasonable doubt that it couldn't have been anything else. And she's already calling it in her testimony potentially multiple substances, cocaine, methamphetamine, or possibly something else. So she's not even certain about what it is. Without a test, without something presumptive to tell you on a test, there's no way of telling what was in that bag. And it's not enough. In a OSHA, we talked about in detail, and I just want to remind you, the root cause they found, they attributed all the responsibility for safety issues to Mr. Elliott. He was defense expert investigator, got an extensive law enforcement experience, if you recall, in APD and military. One of his big points was Mr. Baldwin was not segregated at the beginning, even though he was the known shooter. Hannah was segregated right away. Again, they zeroed in on her in the rush to have her identified. He indicated there was 20 or so key witnesses not identified and segregated. And the problem with that is they can get their stories together and they can change their stories. They can have their memories altered. We know this happened in this case because after the incident, Mr. Baldwin is talking to Sarah Zachary. He's texting and talking to her. Seth Kinney's talking to Sarah Zachary. Mr. Halls is talking to Baldwin after. And so we don't have all the information they're talking about, but we do know they're coordinating, they're talking. The only one not in that group was, and again, this was the idea. We've got to circle the wagons, and we've got to pick out the person that's going to take the fall for everything that's happened here. That's Hannah. That's who they got. Law enforcement failed to follow up on the origin of the live rounds, and their delayed search warrants caused problems with missing. E.J. Pesh testified just this morning. He had said, like everybody else, he's never seen in 35 years an armor split duties with props. It's not possible for one person to keep track of so many firearms. And he indicated it's important to give the armor adequate time and resources, which OSHA said as well. She was not given that. I want to talk to you about the law that the judge instructed you on, and that is the law. What the judge told you about is what we have to follow in terms of evaluating this. The law presumes the defendant to be innocent. The burden is always on the state to prove guilt beyond a reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense. The kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. A doubt based on reason and common sense. So what the government has to do is rule out every reasonable doubt you may have based on reason and common sense. Or in this country, we don't convict people. That's the standard. And again, I go back to where I started at the beginning. If they didn't rule out the reasonable doubt on Miss Zachary throwing away the rounds, that is always going to be there. Because their theory based on you can identify these pictures and we know exactly what was on the set and what remained on the set, and what we will never know that because some of them were thrown away. And we didn't get all of Seth Kinney's rounds. We're never going to know. Other areas of reasonable doubt over the top two, top three. The prop cart was tampered with. We know that right after the incident, another individual moved it. Now, Lieutenant Benavides said he had eyes on the entire time. But if you saw that video, you can make up your mind what you believe. Ladies and gentlemen, his camera appeared to be pointed right into the vehicle, and the individual getting the cart was way off in the other direction. He said he had his head, but you all can decide what you think. The prop cart, there was unquestionably items taken from it. We don't know exactly what those are. That is another area of reasonable doubt that the government has not ruled out. You've had witnesses say throughout the trial you can't tell live ammo from a picture. And the reason is that the FBI said it has to be disassembled and you have to open it up because there's powder in it. If there's not powder in it, then it's not. OSHA stated the root cause of all safety failures was management. OMI ruled this to be an accident, not a homicide. You heard evidence about the esophageal intubation was ineffective to provide oxygen to Helena. This also was a situation in this case where multiple lawsuits have been filed, and you can evaluate their testimony, those people who have filed lawsuits, with care and caution, because they've got an interest potentially in what's happening in this case by being involved in law. Involuntary manslaughter, you're going to have that instruction when you go back. That is the charge that Her Honor has read to you. She's given you the law on this. I want to focus you on a couple key points. The government has the burden to show each of these elements beyond a reasonable doubt. The elements are the numbered items. What that means is if you all have reasonable doubts on any of these elements, Hannah cannot be convicted. And I want to focus you in on element 3, that Hannah acted with a willful disregard. Again, you go back to willful disregard, the nurse example, and the idea that if somebody doesn't know, I mean, that could be the same thing with a nurse on trial for involuntary manslaughter, but if she doesn't know the drug was mislabeled, you cannot hold her criminally accountable for something like that. It's the same thing in this case, because no one knew there were live rounds. So she did not act willfully in anything that happened that day. In loading the firearm, this was another day everybody thought on set. Loading the firearms, running to different things, doing the duties. Nobody's calling her back in for the blocking scene. Mr. Baldwin's doing something on his own. Nobody in the wildest dreams thought there was a lie. Because of that, the next element is that Hannah Gutierrez Reed Act caused the death. I submit to you that what caused her to pass was Mr. Baldwin going off script and pointing the weapon. Now, he didn't know there was a live round in there either. He didn't know. Again, he's in the same position that nobody knew there was ever going to be a live round on that set. But the only ultimate act is pointing of that weapon. Miss Gutierrez wasn't in the church. She didn't point that weapon. She didn't pull it. Nobody called her back in. And because of that, those two elements, I submit to you, have not been proven on involuntary manslaughter. And they have to be. The government has to resolve all your reasonable doubts about that, or they don't. We cannot convict. State and willful disregard, and that is going to be in your instructions. For you to find the defendant acted negligently in this case, you must find that the defendant acted with willful disregard. And so again, that's the terminology, is willful disregard. You're also going to be instructed, the court instructed you, Her Honor, on negligent use of a firearm. And that is a lesser included offense of the involuntary manslaughter. So when you go back and deliberate, you will have this in front of you as well, whether Miss Gutierrez Reed endangered the safety of another by handling or using a firearm in a negligent manner. And again, the language is acted with willful disregard. That's what has to be proven under that charge for you to resolve all of your reasonable doubts. Tampering with evidence, I think this is a real stretch, and it is a real stretch. And you talk about guessing. This one, they have to prove the defendant hid a bag of cocaine. Well, the only witness they have to it said it was either cocaine or meth or something else. So just by the testimony alone, the beginning of that, there's no way of knowing it was a bag of cocaine. It's just impossible. There has to be reasonable doubt on that by the government's own witness. Their only witness. No law enforcement testing, there's nobody else. This is absolutely unproven. You don't even have to get to element 2 because element 1 is not even close to having been proved beyond a reason. Proximate cause, it's a legal term, but it's something the government has to prove as well. And this is where you get into that the passing was a foreseeable result of Hannah Gutierrez's act. The act was a significant cause of the death, and the language I want to focus you in on, in a natural and continuous chain of events uninterrupted by an outside event. What these mean, and these are the legal terminology, what it means is that what Hannah Gutierrez did had to be a foreseeable result, but again, that caused her death. But again, without her knowing that there was a live round, that's impossible to meet that standard. She did not have that knowledge, and there's no witness that came in here in this courtroom in 2 weeks to say she had that knowledge. Without it, nothing she did, she has that willful disregard because she just doesn't know. Now, was there an outside event as well? There was an outside event. There's 2 outside events. Whoever put the live round on set, and then Mr. Baldwin in the end going off script and doing what he did. Those are outside events outside of Miss Gutierrez Reed's control that she didn't know was going to happen. That breaks any idea, and there's reasonable doubt that she had anything to do ultimately with Helena Hutchins' death. Gutierrez Reed was not a significant cause as a result of her death because of the reasons their instruction Her Honor gave you is that negligence of a third person, again, I'm going to highlight the language, if it breaks the foreseeable chain of events. Again, the foreseeable chain of events on that set is you have dummy rounds, you have blank rounds, and then you have an orderly progression with how those are being used. Here we had a completely unforeseeable live round, 6 live rounds that were on set, nobody could foresee. And then we have Mr. Baldwin's action in the end. Those were both unforeseeable to Ms. Gutierrez. The judge instructed you on, you all are the sole judge of the facts. You all are deciding the facts, ladies and gentlemen. And your verdict should not be based on speculation, guess, or conjecture. It goes back to the tampering charge. It goes back to some of the other aspects the government has told you. In this country, we can't decide and convict people on guesses. And that's a lot of what they've asked you to do in several areas, to guess, to assume, to speculate. It's not sufficient to convict people in this country to guess. It's not. And that's what they brought you and they've asked you to do on the tampering and other aspects of their charges. And that's not sufficient. Ladies and gentlemen, Hannah is not guilty on all the counts because of the law that Her Honor has given you. When you apply that law and you apply the standard of beyond a reasonable doubt, she could not anticipate what Baldwin would do. It was not in the script. It was not foreseeable. Management was responsible for safety failures and not Hannah. There's zero evidence of cocaine. There's no testing. And again, I go back to the idea that Hannah is a scapegoat for all the management failures. They do hope she gets convicted, so they're all exonerated. They can move forward. They can finish that movie like Mr. Sousa said they did and make their money. But as he also told you, the buck always stops with production, and it's their responsibility. In any organization, it goes from the top down. And that's where the responsibility lies in this case. That's what OSHA said. That's also the truth. And the truth is important, because justice for Helena does not mean injustice for Hannah. It does not mean injustice for Hannah. It does not mean they get to steamroll her and they get to come in and spin their version of facts and they get to call it true. That's not truth. Is bringing you, ladies and gentlemen, everything they can. Justice is bringing you everything they can. Justice is not mocking theories that could come true, that might have been the case. Justice is not laughing in court during some of our exchanges, and you can evaluate that as to their credibility, whether that was professional, whether if she didn't take court seriously, did she take the investigation seriously? I submit she did not. And so they can't come in here with a straight face and mock us and criticize us and tell you they have given you enough to convict her behind a reasonable doubt, because they haven't.
State's reply.
Hannah didn't know there was a live round on set. I agree. If Hannah knew there was a live round on set and she loaded it into a prop gun and it was used to kill Helena Hutchins, she wouldn't be charged with involuntary manslaughter. She'd be charged with second-degree murder. She'd be charged with first-degree depraved mind murder. This is an involuntary manslaughter charge because she didn't know there were live rounds on set, and the reason she didn't know was through her own negligence, her own recklessness, her own willful disregard for the safety of other people. That willful disregard, that lack of care for the safety of other people that you have seen throughout this trial, it is shocking. For Mr. Bowles to come up to this podium and say it wasn't foreseeable that Alec Baldwin was going to go off script and pull the hammer and pull the trigger, he showed you a video of Alec Baldwin going off script. Alec Baldwin went off script. Hannah Gutierrez knew it. She was there. Hannah Gutierrez knew that Baldwin was loose. She knew it. She didn't do anything about it, even though it was her job. It was her job. It is her job to say to an A-list actor, if in fact that's what you want to call him, hey, you can't behave that way with those firearms. That is her job. That is what they pay her for. That is the job that she applied for. That is the job that she accepted. Foreseeability. You want to talk about off script? Just remember those videos of the stuntman. That's not within the script. She was there. She watched it. She knew these people would go off script. You know she didn't check the rounds. If she checked the rounds, they wouldn't have been floating around that movie set the entire time. And to give you everything we've got. You have absolutely everything we have. This law enforcement team and this team of prosecutors have reviewed thousands and thousands and thousands of photos and thousands of videos. We have interviewed countless people, many of whom you didn't even hear from. We can't stay here forever. You have absolutely everything you need. One of the amazingly shocking things about this case to me has always been, and it's to Detective Hancock's credit, a defense attorney with his own agenda, no question, comes to her and says, it's Seth Kinney, it's Seth Kinney, it's Seth Kinney. That's his job. Okay? Let's make that clear. That's Mr. Bowles' job. He gets Hannah's dad to say, it's Seth Kinney, it's Seth Kinney, it's Seth Kinney. Rather than ignore them, she took his speculative agenda, presented it to a judge, got a search warrant, and searched that man's property. And oh my heavens, what did they find? They found exactly what Thel Reed said they would find. They found live ammunition with semi-wad cutter. You have everything you have. You have everything we have. You have everything you will ever need to convict her. This is 100% foreseeable. Hannah Gutierrez is not a scapegoat. Hannah Gutierrez is not being treated as a scapegoat. Mr. Halls was charged criminally. To his credit, he took an early plea and he got the benefit. Mr. Baldwin has now been indicted. Everyone with criminal culpability has been criminally charged in this case. She's not being scapegoated. She is being treated like everyone else. She is not being given a break because she's a woman. She is not being given a break because she's young. Because that's not how the law... Just review my notes real quick, and as I promised you, I am going to try to... Please keep in mind, Mr. Bowles comes up to the podium and says Sarah Zachary threw rounds away. She did. Obviously she did. She admitted it. She told law enforcement that she did it. And rather than try to prosecute her for tampering with evidence, for panicking and throwing some rounds away, she agreed to come in and testify, and her agreement is that she must testify truthfully. And she testified. You want to know why we don't have an inertia puller in evidence? Why we don't have a box of dummies that Ms. Gutierrez said she brought on set? She said she brought 2 boxes. We've only got 1. You want to know why? Because she went to the prop truck on October 23rd, got access to it, took a bunch of gun belts, and a couple of boxes. She took stuff out of gun belts. You heard from Sarah Zachary that those were gun belts that she brought from another movie set that were already loaded with dummy rounds. Who knows? So I want to make sure that we understand what reasonable doubt means. Reasonable doubt means the doubt must be reasonable. It is not a reasonable doubt to cast suspicion on Brian Norvell. It is not a reasonable doubt to cast suspicion on Seth Kinney. All investigative leads were exhausted. He simply didn't do anything wrong. You want to talk about scapegoating? That's the guy that got scapegoated. Doubt must be reasonable. And I don't have to prove this case beyond all possible doubt. If that is what the law required, my heavens, we live in a world of infinite possibilities. The government would never be able to prove a case beyond all possible doubt. We'd have to have a video of absolutely everything that took place. It's not the standard, and it doesn't have to be the standard. So when you're back there and you're talking about doubt, make sure it's a reasonable one under this set of circumstances. So Mr. Bowles says to you, these production outfitters were just from one day. That's right. All that happened in one day. Imagine what all the other days were like. That was one day. Mr. Bowles is right. The crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job. This isn't Seth Kenny's responsibility to inventory rounds, although he did it. That wasn't his responsibility. Rust Productions didn't provide all of the dummy rounds to the set of this movie. You know from her own statements she brought 2 boxes on herself. We're not living in an alternate reality. All right. When you all go back into the jury deliberation room, you will have your own copy. So you certainly will have a copy to reference. These are some of the instructions that are important. Our verdict should not be based on sympathy or prejudice. Sympathy or prejudice. It can't be based on sympathy or prejudice. And for any of you who are feeling sympathetic because she is young and she is maybe inexperienced, although by her own statement to Detective Hancock, she would tell you she was. All are on this jury because during voir dire you agreed to follow the law. And I will ask you to do it right now. If you had said during voir dire, I can't follow the law, I feel too sympathetic, you wouldn't be here. And if you can't follow the law, you can probably must not concern yourselves with the consequences of your verdict. That is the law. That is the law that you agreed to follow. That is the law that you are required. Gutierrez endangered the safety of another by handling or using a firearm in a negligent manner. There can be absolutely no doubt that Gutierrez should have known of the danger involved by her actions. Yeah, she knew. This was completely foreseeable. She was trained in firearms. She knows what we all know. Guns can kill you. You gotta be really careful. Her act caused the death of Helena Hutchins. 12A is the alternative theory. And so let me explain to you that 12 and 12A are alternatives. You must make a decision about guilt or innocence unanimously to the count, not to the alternatives. So 6 of you can say, I think she's guilty of 12, but not 12A. Another 6 of you can say, we think she's guilty of 12A, but not 12. Done. You're done. Gutierrez loaded live ammunition into a firearm. Yes, she certainly did. She told the police she did. She failed to perform an adequate safety check of the ammunition. Of course, you know that. She didn't do it just once. She did it numerous times. She acted with willful disregard for the safety of others. So you are being presented with what's called a lesser included offense. And I will remind you the instructions that the judge read you at the beginning. Your first job is to see if you can agree on involuntary manslaughter. If you find her guilty of involuntary manslaughter on either alternative, you do not move on to this misdemeanor. It's done. If you find her not guilty of involuntary manslaughter, then you get to move on to the misdemeanor. A lot about that, I'll skip it. This is what we call a general criminal intent instruction, and I want to just make sure that you understand this instruction only applies to the tampering with evidence. It does not apply to the involuntary manslaughter because she is charged with negligent homicide, not intent. Very importantly, are the proximate cause jury instructions. These jury instructions are what allows you to find Ms. Gutierrez guilty, even though Mr. Baldwin may have also been a significant cause of the death of Helena Hutchins. So that was a foreseeable result of Hannah Gutierrez placing a live round into a firearm, of course. The act of the defendant was a significant cause of the death of Helena Hutchins. The defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death and without which the death would not have occurred. Got a bunch of live rounds on set, accidentally, but negligently. She loaded one of them into a prop gun, and this was after they were loaded into Jensen Ackles' gun belt and Alec Baldwin's whole. And she told Dave Halls, this is a cold gun. He told the crew, it's a cold gun. At that point, everyone certainly assumed that there wasn't a live round. She knew Baldwin would go off script. She didn't have prop duties to tend to. She walked out. And even if she had been there, it wouldn't have made a difference, because you have seen the incredible lack of control that she exercised as the only person on the movie set in charge. There is no intervening event. If you think the intervening event is that Baldwin manipulated, that's the whole purpose of the prop. He's gonna manipulate it. You saw a bunch of other. Very importantly, there may be more than one significant cause of death. If the acts of two or more persons significantly contribute to the cause of death, each act is a significant cause of death. Baldwin's act was a significant cause of death. That's okay. You can still find the negligence of a person other than the defendant was the only significant cause of death, or constitutes an intervening cause that breaks the foreseeable chain of events, the defendant is not guilty. That's not this case. She brought the live rounds on set. She put a live round in a prop gun. That's the reason that Ms. Hutchins is dead. One of at least two. I will again thank you very much for your time and for your attention. I know that this has been hard work for you folks. I will ask you to find Ms. Gutierrez guilty of involuntary manslaughter and tampering with evidence. And I will ask you to bring some justice to Helena.
Instruction number 22. I will now ask you to retire to the jury room to begin your deliberations. You will be provided a copy of the jury instructions, and the exhibits introduced as evidence will be made available to you. Prior to beginning your deliberations, you will need to select one of you to act as foreperson. That person will preside over your deliberations and will speak for the jury here in court. Forms of verdict have been prepared for your use. You will take these forms to the jury room. When you have reached a unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits to the courtroom. There are 12 that deliberate. There are 4 alternates on this jury, given the long length of this jury. Keeping with the privacy, I'm going to pass this instruction down with the help of Ryan. You're going to look if this is one of your names and you are one of the alternates. What I'm going to ask the bailiffs to do is to first take the alternates out so they can get their belongings, and I'm going to ask you to meet me down at the end of the hallway to explain. I hate to tell alternates they're alternates because they've been paying so close to the evidence, and so just to talk with you, and then and thank you, and then right along on your clip will be the jurors themselves, okay? And the jurors will go into the room, so I'll need the aid of both of them. But first, let me pass this piece of paper over to you. Look down here. There's 4 names. See if one of them is yours, and you're on. Follow the alternates. Follow Ryan. I'll meet you down at the end of the hallway after you get your belongings, and then you'll follow with it. In recess, I'll be back in, but we're in recess. You can get going with your exhibit quote mark to the language in instruction 20, and I think it can be found in the second paragraph. Do you have copies of the instruction? You can share an extra copy I have if you want.
Yes, Your Honor, we do have it.
Yeah.
You don't have a hard copy? I have one of the previous.
All right, here.
Don't think that changed.
Are you gonna share, oh, Mr. Bowles has it, okay, so it says, instruction 20, quote, or constitutes an intervening cause that breaks the foreseeable chain of events, end of quotation marks. Clarification on if, quote, intervening cause, unquote, could mean things that could have been changed to prevent. You can read this.
Thank you.
Mhm.
Thoughts about how to respond?
I'm just going to tell them to,
Just
we,
keep
yeah,
doing it.
we can't help. All right, we're in recess, thank you. All right. Just a minute. All right, ladies and gentlemen of the jury, through the foreperson, have you reached a verdict?
Yes.
All right, let me see the verdict form.
She needs a hearing.
All right, so let me repeat. I said, ladies and gentlemen of the jury, through the foreperson, have you reached a verdict?
Yes.
All right, and do you wish to read the verdicts?
Sure.
Okay, I would start with count one.
Count one.
Okay, you have both of them. Will the defendant please stand?
We find the defendant, Hannah Gutierrez, guilty of involuntary manslaughter as charged in count one. We find the defendant, Hannah Gutierrez, not guilty of tampering with evidence as charged in count two.
All right, thank you. You may be seated. Let me get those forms, retrieve those forms from you. I'm going to do what's called polling the jury. What I need to put on the record is that this is your individual verdict, okay? So I'm going to start with the gentleman in the back. Is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes, Your
Sir, is this your verdict?
Yes.
Sir, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict? Ma'am, is this your verdict?
Yes.
Ma'am, is this your verdict? Okay, thank you. All right, so you've completed your service. Thank you so much for being here. It was a long trial. People may want to talk to you. You know, this has been pretty much a lot of publicity, and you don't have to. Okay, so you can just simply say, I do not wish to talk, and move on. And if anybody bothers you, we've really tried to protect your privacy. If anybody bothers you, simply call my division, and we'll figure out what to do. But you also may talk, okay? So it's entirely up to you, okay? All right, so you can escort them.
All rise.
George, you should pop. You may be seated. All right, is there anything that the state's requesting based upon the verdict?
Your Honor, we would request that Ms. Gutierrez be taken into custody.
Mr. Bowles?
Your Honor, we would request under, I'll pull up the rule, Your Honor. Rule 5402, release pending sentencing in this court's discretion under the same conditions or other conditions as this court would deem necessary. Ms. Gutierrez has been on conditions. She has not violated those conditions. She has voluntarily appeared at all court proceedings. Your Honor, I would request this court to continue conditions or whatever conditions this court would have on release.
All right, thank you. I'm going to remand you, and the reason why I'm going to remand you is you are now convicted. And so, and this is a death from negligence, but it's still a death. And so, deputies, you're going to take her into custody, and we will set a sentencing date. What is the best, what do we want to look like on that? And we need an order of remand, do we? Haven? Okay. Counsel?
In terms of the sentencing date?
Yes.
At the court's convenience, will be available. There are 2 weeks in May that I'm unavailable. Those are the last 2 weeks of May.
All right. Mr. Bowles?
Your Honor, as soon as this court has time, we will be available.
All right, so do you have any conflict like that? She said May. Do you have any conflict?
I don't know for sure, Your Honor, that I could. I do have other trials, but I think mid-May.
Well, I can do it sooner.
Okay.
I just wondered if you had any conflicts along the way.
Doesn't look like mid-May, Your Honor. I do. I don't think I have any conflicts.
I'm sorry, I'm not understanding. Do you have, okay, we're in March. Do you have time before May?
We have time in April.
Okay,
Sure.
all right, okay. All right, anything else before the court?
Nothing from the state, Your Honor.
No, Your Honor.
All right, thank you. We're in recess.